Thank you very much for joining us today. My name is Faith Alube. I'll be your moderator for today. I also work at the Kenya Land Alliance as the Executive Director. Today, we'd like to talk about realizing a people's responsive oil and gas sector in Kenya. And we want to derive lessons from Turkana. Turkana people, they'll join us, they will tell us their experiences. But other than that, we have experts who will join us to just give us some insights from their work that they do, from the interactions from the communities, so that we can just gain to understand, was there oil in the first place? Did the Turkana people benefit? Did Kenya benefit? Was the policy framework, did it suffice? Which balls were dropped? Do we have a second chance to just correct what went wrong in the first round? The main objective of this forum is just to understand how can we approach the oil and gas sector in Kenya in a multi-sectorial, multidisciplinary way, so that every other discipline can enrich the process, every other sector can benefit from it, so that it's just not about land, it's just not about upstream politics and downstream benefits. So today, karibuni sana. I'll be mixing English and Swahili because we have members from the community. And to start us off, I'll just like to introduce Kenya Land Alliance. Kenya Land Alliance is hosting this virtual meeting together with our partners from NEDO. NEDO is from Turkana. We have the Kenya Civil Society Platform on Oil and Gas. We have the Kenya network on Oil and Gas. And then we have Lumumba Ondeda, a consultant and a giant amongst whose shoulders we stand on, Karibu Sana Lumumba. And then we have the MCA from the county. Just to introduce our panelists, we have Muturi Kamau, representing the network. He's the network coordinator. Muturi, karibu kabisa.
Asante sana. Great to be here.
Then we have Mama Veronica from Turkana. Mama Veronica works with women to just amplify women's voices at community level in regards to oil and gas. Karibu sana, Mama Veronica. Mama Veronica, asante sana. Then we have Charles. Charles is the coordinator of the Kenya Civil Society Platform on Oil and Gas. Charles works mainly on development and policy formulation. Karibu sana, Charles.
Okay.
Then we have Janet Milongo. Janet is an advocate of the High Court of Kenya. She'll be helping us understand a case that was trying to get justice, land justice for the people of Turkana. Karibu sana, Janet.
Thank you very much.
Then we have Lumumba Ondeda. Lumumba, karibu sana.
Yes. Santi.
Nice to have you.
Pleasure.
Pleasure. Then we'll be joined by the MCA from Turkana in a few. Before we start, I'd just like to introduce Kenya Land Alliance and also introduce some quick facts about oil and gas in Kenya. Yes. So Kenya Land Alliance is an umbrella organization that brings together land non-state actors that advocate for people-centered policies in regards to land governance. Kenya Land Alliance has brought together some partners so that we can just understand where this conversation is at and how can we, because Talo is selling out. Last week but one, Talo was summoned by the Senate and they made presentations. We just want to understand where the conversation is at and how can people meaning land, people meaning trade relationships in Kenya, investors, upstream politics, downstream benefits. How can the oil and gas sector be people responsive in Kenya? So I've said Kenya Land Alliance is an umbrella network of civil society organization. It was founded in 1999. It is a membership. If you want to be an individual member, it is 2,000 shillings per annum. If you're an NGO and you'd like to be a member of Kenya Land Alliance, it's 5,000 shillings. If you are a CBO and you'd like to be a member, it's 2,500. If you are an INGO, an international organization that you'd like to be a member, it is 10,000 shillings. Once you get in touch, we are going to tell you what benefits you'll be able to derive as a member, but there are multiple, there are myriad of benefits you'll be able to get. Kenya Land Alliance, we work towards 4 result areas: active agency of land marginalized groups like the Turkana communities. We work towards strengthening land governance in a bottom-up approach. We work on ensuring that all our advocacy is knowledge-driven so that the interventions are more practical and more important for the people that it will benefit. And we work towards revamping our membership every other time. So quick facts on oil and gas in Kenya. Oil was discovered in 1940 in Kenya. So before even the colonialists packed their bags and left Kenya, they had known that there is oil in Turkana. There had been some semblance of exploration from 1954 to 1992. In 2010, Talo, a proponent, showed interest and was given a license to prospect oil in Kenya. They partnered with Centric Energy and they signed an agreement to prospect. In 2012, the Kenyan government announced a commercial discovery, and the communities from Turkana will be telling us about their experiences once they heard that there will be oil in Kenya. In 2012 to 2015, what has been happening, they've been measuring the content of oil beneath. Is it commercially viable? Can Kenyans benefit? Is it worth going the whole hog? In 2013, there's the first pit was explored to understand the levels of oil that is available. That's a map of where the oil wells are, and we'll be talking more about this because as I've told you, we have experts. In 2016, the earliest oil operations started. They wanted to know, can we export? That's a photo of the president flagging off the first EOPS early oil pilot scheme. And then in August 2018, there is a second stoppage where there are just issues because the community indicated that they were not consulted. In August 2018, there was trouble where we were even witnessing the community just closing the roads because they had not been consulted. The community are represented here by the MCA and by Mama Veronica. They are going to tell us more. So now, in 2020, Talo declares a force majeure. So we want to understand, where is that conversation? What can be done? So at this point, I'd like to start with Mama Veronica. Mama Veronica, karibu sana. Vile nilikuwa nimesema hapo mbeleni, tunashukuru sana umeweza kuungana na sisi siku ya leo. Tunashukuru sana pia umeweza kuleta kina mama wenye unafanya nao kazi pale mashinani. Sasa ningelipenda tu kuelewa kutoka kwenu kama kina mama wa Turkana. Wakati mlisikia kwamba mafuta na gesi imepatikana kwa nchi ya Waturkana, nchi iliyokuwa imetengwa kwa muda mrefu, mulijipanga aje? Hisia zenu zilikuwa aje? Mulijipanga aje? Na wakati unanijibu hiyo swali pia ningelipenda uniambie ni nini yenye amukufanya unaona kama mungefanya mungeweza kufaidika zaidi. Kwanza mulifaidika? Karibu sana Mama Veronica. Unaweza unmute your microphone ndio uweze. Karibu sana Mama Veronica. Natumai umenisikia.
Asante Alube. Tuliposikia mafuta imekuja Turkana mara ya kwanza, tulikuwa na expectation, very high expectation ya kupata ya kwamba maisha ya Turkana itabadili na tutakuwa watu ambaye tumejumuika na kampuni pamoja, tufanye kazi ili Turkana iweze kujipatia development ingine kuhusu mambo ya ujenzi, mahospitali, mashule, wamama kupata kazi. Hiyo ndio ilikuwa tegemeo ambayo tulikuwa tumeionelea mwanzo. Na kuangalia ilipokuja ndani ya exploration yao wala waka conduct survey, tuliona there was a lot of things that were changing kwa mambo ya wenye walikuwa wako na experience na watu wenye walikuwa hawana experience. So hapo ikakuwa pia ni shida watu wengi wa upande yetu kupata kazi kwa wingi, hawakufaidika. Lakini wakati kazi ilipokuja, kuna wachache ambao walijipatia kazi, na nikiona ndani mambo ya wamama haikuzingatiwa sana. Hadi wakati tulipoamka tukasema ni haki yetu pia sisi wamama kupata kazi, kwa sababu baada ya muda fulani we are the ones taking this food to the pot na tupike kwa nyumba na inakuwa shared. So tukaanza mambo ya small CBOs, tukaanza kwanza groups, ndio tukaforma CBO. Kama maendeleo ya wamama tukaamuka pamoja tukaenda. So in that case we were forced to look down to form an advocacy team or a platform. Tukuwe na watu ambao they can be our voices, we can be able to be heard. So kwa hiyo tulipata kuzingatia na wamama fulani wakafaidika. Wakapewa kazi kama ya kuleta mambo ya mboga, wakaleta mambo ya dry foods. Sasa kutoka hapo tukaanza kujua hii ni wakati wetu pia sisi kupatikana kupewa fasi ndani ya kampuni ya Talo.
Sasa wakati unazungumzia ilifika wakati kina mama wakaanza kujipanga. Ni changamoto gani zenye kina mama waliweza kupambana nazo wakati unazungumzia ardhi pale mashinani?
Changamoto ni kwamba majority kwa kazi ambayo ilikuwa inapatikana ilikuwa ni wanaume. Hata mambo ya tendering ilikuwa ni wanaume. So tukaona kama tumefinywa sana. Kwa sababu unajua ukikumbuka historia Turkana hapo before, wamama wako wanasingatiwa. They were not given that room to play a role in something. Even when they are making decision making, they were not invited to be among the teams. They can just decide na kusema imeisha. But we had to fight. Tukaanza kusake voices, tukaanza kutafuta wamama wenye wamesoma Nairobi, wenye wanajua mambo ya sheria ambaye inazingatia kupigania haki ya wamama. So tulipopata hiyo, we had to come together na kusema it is the one voice that we have also to be heard. Tukaenda Talo, tukastrike kama wamama, tukaenda mahali pale, we were invited na tukakaa chini. Tukapata nguvu ya kupenya. Tukasema hata mkichukua yote lakini hiyo 1/3 mtupatie. So kuna wamama ambao walipata kazi, wamefaidika, na bado tunaangalia kwa sababu mashinani tukaona huko chini wale wamama ya huko chini kabisa kwa grassroots hawajaonja utamu ya kupata mali ya kujishikilia, hata kuforma group, hata kukua member ya mali. So unapata hawana sauti, they just see things pass, zinakuja zikipita. Tukasema hapana, wakati wetu. Na kweli ilitoa hiyo kampuni ikapatia kazi, na ikampa kazi ambaye ni mambo ya kupeana perishable foods, fruits, mamboga, na ikikaa siku 2 hiyo mboga ina stale. So tukarudi tukasema next time kama tutapewa chance, sisi tungetaka kushare mambo hata ya dry foods na nini, na pia tuangalie kuzingatia wasichana wa Turkana. Wengi wao wanapopata mtoto anakaa, anajisahau, anaona it is the end of the world. No. We had to go back and tell girls it is time you wake up, go back to school. Tunasaidia kama CBO yetu inasaidianga hata msichana mwenye ana drop na anasema ana school fees, you just take her back to school. Pia unaelezea wazazi wao watoe kidogo, na unapata inakuwa very productive. Some of them wakimaliza they turn to be teachers. Some of them can get a good job that they can earn better money. So women, we must wake up and fight on something. Just to take you kidogo to the background ya Waturkana. Au unajua ndani ya Waturkana kwa wamama, hii lani huwa tunasema kwa sababu ancestors wangu walikuwa wanaishi hapa, mna grow mkiinherit hiyo maneno. ya kuwa kwamba, lakini mwanamke hapewi ruhusa ya kuown land. But for now, that was those days. But today, we've also opened our eyes that you can own a land, you can buy a land. Unajenga manyumba ya biashara, unajenga tuduka kidogo, vioski watu wanaweza komboa. So wamama pia sana wamekuwa washikadau ya kufanya vitu kama hizo. So for me, I feel kutoka saa hizi hadi hiyo maisha yenye nakuja baadaye, we must have people who can voice women, empowerment, entrepreneurs. Yani tuweke vitu ambaye mwanamke anajua I can do this better. You know, men say wanawake wajui kitu, but we know so many things than men. That's why God made a woman somebody who can persevere and have her own problems. Na anatembea anabeba watoto yake anawalisha, anawasomesha. We are strong.
Asante sana Mama Veronica. Thank you very much for sharing. Charles, I'd like to bring you in. It's clear that by the time Talo started working, there was limited consultation. That is why you can hear the expectations were quite high. That means no one spoke to the communities about what to expect even before they started working. What was the procedure? What was the PSC before even, was there a PSC? Is it public information? What policy frameworks were supposed to be put upstream in order to benefit Mama Veronica and our ilk pale mashinani?
Okay. Yeah, thanks for that introduction, and it's a pleasure to join this session. On whether there was a PSC, there was a production sharing contract, but again, over the years, this has changed. So you had the initial partners, which, like you mentioned, Centric was involved at some point, Turkana Drilling was at some point as well. And then more recently, Africa Oil had sold to Musk, and then now Musk sold, or Musk was taken over by Total. So over that period of time, I mean, there's been different changes in the ownership structure of the joint venture partners in Turkana. Now, the challenge with that, and which is what we're experiencing now as well, is that a lot of this activity is all Nairobi centered, right? So when a company first comes, I mean, the negotiations are in Nairobi, the production sharing contract is going to be signed from, Nairobi, and communities will only get to know what's happening once the company goes to the ground. So this effectively locks out the citizens from the process. And even currently, as we speak, even due to force majeure, Talo and its joint venture partners are in discussions with government. But on what we don't know, and even after the negotiations are complete, there'll be likely no disclosure on the outcomes of those negotiations. So a huge challenge that prevents oil and gas from being responsive is the fact that a lot of the agreement-making process is a centralized process, and people who will be impacted will only be informed of it once the agreements have already happened.
Just a follow-up question. There's always that balance that has to be looked into. The right to the public, the right of access to information for the public, to the public. And then each contract has the confidentiality clause, like you cannot disclose how much we make. We are the ones who declare cost of oil. We are the ones who do this, who do that. How do we balance those two? Because there's always that competition that the public has the right to understand what a contract, what a PSC contains, but at the same time, also the company has a right to some confidentiality. How do we strike that balance when it comes to oil and gas issues in Kenya?
Yeah, so what has been proven over time is that this idea of commercial sensitivity is largely a myth. If you look at, there's a contract, there's a website called www.resourcecontracts.org. And if you go on there, you'll see contracts from all over the world. And a lot of those companies have not been impacted through that. There are a few sort of addendums in some contracts which might, involve some proprietary, sort of software or that kind of thing that needs to be protected. But majority of the PSC. And when we speak of the PSC, we are looking at sort of the critical terms. What you want to know, for example, is are the parties who are party to the contract actually capable to undertake the work that they're signing up to do? The other key thing that you want to see is, for example, the revenue share between national government and the company over time. You want to look at sort of what cost recovery audits, at which point are there. So there's some critical things which is what majority of people want to know. And those things are not commercially sensitive, and those need to come out. The other thing, at least in Kenya, with Article 35 on access to information, the one key thing that we lack is also proactive disclosure. So there's one thing to say, okay, if you ask for the information, then we'll take you through a longer process of accessing this information. They should, I think it's 35.3, which says government must also be proactive in disclosure. And that's what we are not seeing at all. There's no proactive disclosure. We are having to push. We are at the CAJ now trying to get the contracts to be disclosed. They haven't been disclosed yet. And so it's a fight that we continue.
Thank you very much, Charles. I'd like to bring in Lumumba. Lumumba, it's clear that the oil and gas is on land, but the people even who live on that land have never been consulted. There are issues that they've never understood how to pursue. How do they benefit from it? There's the issue of benefit sharing vis-a-vis CSR. There's the issue of land tenure issues in Turkana. And I'd just like you to help us understand what are the arising land tenure issues in Turkana, and how can Turkanas understand that we have a second chance to look into them again?
Thanks, Faith. I want to do this in under 10 minutes, but I also want to have a reference to some slides that will help us appreciate what it is we are talking about.
Yes, you can share your screen.
Sorry. Okay.
Yes.
Can I proceed now?
Yes, you can proceed, Lumumba. Thank you.
Okay. I think it's important when we are talking about how the Turkanas will benefit. I think this is which one now? I started with the issues arising. Just a minute.
You can run the slideshow, Lumumba.
That's what I'm trying to get at.
Yes. Perfect.
I think I'm mixing up myself. Just a minute. Are we there now? Okay. So I was basically saying, I hope my slides are being seen.
Yes, sir, we are seeing them.
Okay. I was just saying that I think for us to appreciate, there are two working definitions I want to share. And these definitions are not very far-fetched from us. One of them is one which was provided by the African Union, basically African Commission. It was also one with the Economic Commission of Africa, the African Development Bank in consortium. And this gives us a level to understand that land tenure is just basically about the nature and the manner in which rights and interests over various categories of land are created, determined, allocated, and enjoyed. Now, in this particular circumstance, we are talking about the customary tenure of the Turkana people, how it is determined, how it's enjoyed, and how it is shared with others. I think that is the very first element. The second element, you rushed to the next time, is basically to say there are normally terms and conditions under which the whole process of accessing, acquiring, retaining any acquisition is done. And I think that is very, very key. That is where I would be asking, what did the Turkanas agree on going forward with the company? And even when the company changes from one place, what is their role going forward? I think that will be the first element. So the issues for me then comes to be when you look at the Kenyan land laws and the policies, they seem not to give community land the same protection it gives the private and public land. And this is because community land is yet to be firmly recognized, protected, and registered. And therefore, to some extent, you could say it is not yet recognized in Kenya that the Turkana people's land is their property. It would appear it's just a territory which they occupy, which they don't have ownership over. And I think that is where the first problem comes, the first issue we need to deal with. The second issue about this tenure system is the land administration that exists. It would appear like the community have their traditional manner in which they manage their resources, especially resources that go to their pastoralism. They know when to manage, where to use, when to access what, and what to go to doing that. But to some strange arrangement, the land administration that is envisaged, where the community land management committees will come into place, has never taken place. And therefore, it leaves us with a very flat situation where we don't know the borderline, what kind of land administration is in charge of processes. The other thing is that the count of Turkana itself, as part of that institution that invested with the mandate over community land, it has no appropriate mechanisms to steward the community land and resources out there. And therefore, because they don't have that in place, their imagination is that the Department of Lands in Turkana is in charge of that. But sincerely, it is not in charge of doing that. The other element is that when the land reforms were being in place, one of the first things that is expected of the government, both at the national and county level, is to document and map out the existing land tenure systems. That is not happening. So because of that, that element brings us, gives us the first problem. So how can then the communities discuss the benefit sharing realistically under that circumstance? My first point would be that from the standpoint of investment in their property, they ought to be benefiting as communities and their economies. Now, their economy is pastoralism. The modern investment is in oil and gas, which is an extractive material that might not quickly relate. The question then is, how do you manage from that standpoint that the benefits accrue to the communities? The other element in realistic negotiating this is also to bear in mind that the use of land by investors requires that the area in which they're investing is already planned. The land use is planned. In this particular circumstance, that land use planning ought to be done prospectively. In this circumstance, it has not been done. The other element is that for you to anticipate negotiating proper benefits, you need to be guided by the legal policy institutional framework to ensure that the benefits as they accrue at all times, they are shared equitably. That is not in place. The other element is that there is no free access to any information that's being disseminated about investment in Turkana. And that leaves the community in a very bad shape. Having said that, very quickly, moderator, if you would allow, there's this whole element of how do we then talk about benefit sharing mechanisms versus cooperative social responsibility in matters of benefiting the community. I would say that the bit of discourse that seems to be going on is about how do we put natural resources wealth to best use for sustainable development. But it's not how do the communities really benefit essentially out of the resources in their midst. Corporate social responsibility, by the way, is a subset of benefit sharing mechanisms. It's not the whole it. It is something which a company does to gain social acceptance by the community. It is something they willfully do. It's not mandatory. And actually, what the corporate social responsibility does is basically part of the public good that the citizens will be expecting. So benefit sharing must be born from the reality that the land-based resources is supposed to benefit the well-being of the community because the resources in their midst, but it's managed by the state. So the community negotiates that essentially from the point of being an access to the resource that is being exploited. And for you to do that, you need a well-developed mechanism of that benefit sharing. And if it's not in place, the benefits will not go far. And I think for me, that is the first element I would say that looking at all these things from the tenure system to the point of benefit sharing, the Turkana community have opportunity to go back to the drawing board, given now that the company that did the exploration has exited and there will be further negotiation with whichever company will take over. Unfortunately, if we are not very careful, the community will not be involved at that stage. And I think that's what Charles alluded to. Those negotiations seem to be taking place in Nairobi. The county government is with very limited knowledge on what to do to engage those at Nairobi. And those at Nairobi seems to be more interested in attracting investment other than promoting the well-being of the Turkana community.
Thank you very much.
Back to the facilitator.
Thank you very much, Lumumba. Lumumba has alluded to the fact that CSR is tokenistic. As much as communities expect and appreciate CSR more than BSM's benefit sharing mechanisms that are put in policy, that are predictable, that are more accountability friendly. We need to rethink that. We need to rethink that so that communities can understand the differences. Thank you very much also for mentioning the issue about community land. The community land registration process is ongoing, and the county of Turkana is supposed to play a very big role in ensuring that their lands are not only registered, but their communities are also registered. We have been joined by the MCA from Turkana, Mheshimiwa Rafael Loperito. Bwana MCA, asante sana kwa kujiunga nasi. Unaweza unmute yourself so that uweze kuzungumza. Asante sana kwa kujiunga nasi Bwana MCA. Umesikiza panelists wengine wakizungumza. Kama kaunti ya Turkana, mko na jukumu la kuweza kuwakilisha watu wa Turkana, na wewe pia uko na jukumu zaidi kwa sababu wewe ni chairman wa kamati ya land na natural resources. Sasa kama policy maker, unatengeneza sheria pale county, umeweza kuangazia shida na changamoto zenye watu wako wanapitia, na sasa venye tuko na nafasi ingine ya kuweza kujipanga tena, mnafikiria aje kama kamati? Karibu sana mheshimiwa.
Asante sana. Ingawaje nimeingia tu saa hizi nikapata mkutano ni kama imeshaendelea.
Uko tu sawa.
I just want to do some corrections. I used to be the member, the chairman of that committee some last term. But this time around, I'm a member. But I know I am much involved with issues that touching, especially my community where I am representing. So far, we've done little. We've done little on land because there was a lot of confusion, especially on the case that was taken to court. Since then, nothing has ever been done by the government, especially the Turkana County Assembly. We are almost getting confused, the rest of us who never participated in court. But according to the office of the attorney in the county, we are informed that when the ruling was done in Kitale, they decided to appeal. And up to date, there is no communication completely. You remember last time when we had a meeting at Stegra, we discussed again on the issue of land. There was a lot that was coming up, but we found that we are risking as a community because we were given a time frame to discuss with the national government on what conspired on our land. But up to date, there is no proper communication that is coming out, especially for us who are representatives. There is nothing that is coming out here. But the issue of land is just moving on because I'm told there is registration cycle that is moving on from one state to another, So the government is in the process to make sure that every stage has been completed. My worry is if the whole process is going to be completed, and yet the county government has done nothing, we stand to lose the land. I think the national government, and the national government can decide to do anything they want. So that has been my plea to civil society, that you rise up and support Turkana County Assembly so that you open up our mind. We see how best we can approach this issue to safeguard our community land. So far, we are not sure whether the issue of community land is coming out clear in Turkana land. Yeah.
Asante sana Mheshimiwa. Sasa a follow-up question to you Mheshimiwa. Apart from the land issue, kuna mikakati mingine ama kuna policies zingine zenye county imeweza kupitisha kuweza kuchunga Waturkana pale mashinani?
Turkana County Assembly hatujatengeneza sheria yoyote ya kuchunga our community land so far. Kwa sababu wakati walifunga kila kitu, there was no registration of land, there was nothing, we've done nothing completely. So walisema governor ali-communicate, akasema mambo ya land isimame mpaka wakati watafungua. So there is no direction completely.
Sawa sawa, asante sana Mheshimiwa. I'd like to bring in Janet. Janet, we know that the issue of social licensing and social legitimacy is missing in this whole conversation. And there was a case that the County of Turkana filed. It's a unique case because the County of Turkana was taking NLC to court. So the government was taking the government to court. An agency of the government was being compelled to perform. Maybe you can just give us snippets of the case so that we can understand that there was an attempt to clarify the land tenure issues in Turkana.
Yes, thank you. In that there was a case instituted by the county of Turkana, LC, and the Attorney General Interestingly, there's also a case instituted by the residents, community members, against the county government and the national government. So there were two cases that eventually ended up being consolidated. And that is the
Okay, Janet, it seems like we've lost you a little bit. You can hear us? Janet? Janet? Okay, as we try to get Janet, I'd like to bring in Muturi. Muturi, we understand that there are a lot of environmental impacts because of the oil and gas extraction. There are issues of flaring, there are issues of storing of poisonous cuttings, and the waste management policy. So as an expert on environmental justice, what component of waste management was not contained in the initial PSC? And how can we ensure that this time round, we are able to ensure that it's there? Muturi?
Thank you, Faith. First and foremost, we need to appreciate the fact that environmental governance has come a long way since the initial stages of oil exploration and discovery. There have my colleagues from Nakula.
Muturi, you have an echo. We can't hear you. Muturi? Muturi? Okay. Muturi? We lost you a little bit there. You can hear us? Muturi? Okay.
I think, Faith, we are having a problem of the internet. The internet is coming to
okay. Muturi?
you can hear me now?
Oh, Janet is back. So
sorry about that.
As we sort out Muturi, Janet, you can continue as Muturi sorts himself out. Yeah.
Okay. So I was saying the interesting scenario here is that we've had two cases that were consolidated. First case was initiated by the county government itself against the national government. The second case was by community members against the county government and national government. So these cases were consolidated and the issues are basically the same. Issues being that both the county government and the community members are complaining of a lack of consultation. They were not involved in the process of the national government undertaking compulsory acquisition measures. As far as they're concerned, they just saw notices in the Kenya Gazette and they feel either totally or just inadequately consulted on those matters. Now, the case brings obviously interesting issues of public consultation and public participation. As you know, the Constitution envisages a situation where both levels of government work in consultation with each other. Therefore, it is not one level of government undertaking its functions to the total exclusion of the other level of government, especially when it concerns the other level of government, in this case, the county government. Therefore, the county government's contention is that it was totally not consulted. And even in that case, interestingly, you see the national government defend themselves, claiming that they did have consultative workshops. The consultative workshops, according to
to Janet.
Judgment seem to have taken place within only about
Janet, if you can
3-4 days.
Okay.
And they seem to have targeted community members.
Janet, it seems we've lost you. Let's go back to Moturi. I can see it's set up now. Moturi, you're good to go. We were talking about the environmental.
Hello, can you hear me?
Okay.
Can you hear me now?
That is better, but Janet, get a better connection so that we move along. Yes, we can hear you. Okay, and then we've lost you again. I think let Moturi finish. Moturi?
Yes, as I was saying, under the Environmental Management and Coordination Act, which under Section 65 mandates that project proponents need to undertake an environmental and social impact assessment. So once Talo acquired the block 10BA, 10BB, and 13T, they had to undertake block EIAs. That essentially just understanding the ecological services as well as the social services, and this is just putting it down so that they're able to appreciate the indigenous technologies, the political dynamics, the culture and beliefs of the Turkana people. So that happened up until, because they had to undertake that prior to beginning conducting 2D and 3D seismic survey on the respective blocks. So moving from that, there were already issues that had been identified, because once they had finalized with that is when they began exploratory drilling. And this pretty much involved the setting up of the drilling rig to understand, to get more data on the oil reservoirs. So moving from there, the second stage, once they hit commercial quantities in 2012, was they began the early oil pilot scheme. And for the early oil pilot scheme, they also had to undertake an independent EIA for that matter. And this was pretty much because they were to conduct extended well testing, whereby for you to understand how the extent of your reservoir. Turkana, the South Lokicha Basin has an estimated 2 billion stock tank oil in place, but whatever is recoverable is the 560. So for them to understand how the oil is in around Srida, how it is around undertake what is called water flooding, which is pretty much continuously pumping water into the reservoir, so that they're able to see how much oil they can acquire from that. So from the early oil, there are also issues, and I'll be able to just highlight some of the issues that came about. They moved then to now undertaking an EIA for the Lamu-Lokicha crude oil pipeline, which was finalized last year. And currently, as we're speaking, they actually finalized, and I believe they've submitted to NEMA an environmental and social impact assessment study for the foundation stage development. Now, there are a number of key environmental concerns. One is on the mud, the mud that they normally use to cool the drill bit, as well as ease on the drilling of the well. So it's normally most companies prefer using oil-based mud to undertake the drilling, and it has its own toxicity levels. And oil-based mud has been attributed a lot of the times to having high concentrations of benzene, which is a carcinogenic compound that pretty much has brought issues to we've had cases around, especially around the areas of Twiga and Gamia, where there've been reports of livestock dying as a result of the contamination of such waste. So it's become a really big problem. And they even have documented pictures from the communities who work on the ground, where a few years ago it rained and with the landfill where they were holding the landfill or the pump where they were holding the mud waste, the drilling waste, spilled over to the adjacent environment. To take you to the case study that I had mentioned earlier, in 2017, Turkana Empowerment Advocacy Group, as well as NEDO, wrote to NEMA to compel a company that wanted to set up a waste hazardous waste handling and transfer facility in Kangpetain in Lokori. And the gist behind that letter was the communities felt that there was inadequate community consultation. And NEMA responded to that effect and wrote to the company to just tell them that they needed to give them some of a stop order and told them to go back to the ground and undertake that. But because of continued citizen action, and by now I know you're well aware that the Turkana community is well empowered to stand and advocate for their rights, them being agents for change. So they were able to even stop the company from setting up in Kangpetain, which was a very rich, an area rich in ecosystem services. So these are some of the challenges that they've been able to go through. Again, you mentioned the case of gas flaring. Gas flaring has been continuously going on, even when they were undertaking extended well testing. We know that from other jurisdictions, flaring is undertaken to ease up reservoir pressure, as well as sort of burn the waste. But what communities have expressed concern is that there's sort of residue from the gas flaring that normally settles around the vegetation that is consumed by the livestock, which end up having implications. There have also been cases of miscarriages. So these are some of the things that we really need to interrogate when undertaking EIAs. A lot of the EIAs, if you're looking at just the policy, just to take you back to the policy framework of environmental impact assessment studies, there's the environmental impact assessment regulations of 2003, but they have not, they were not, at the time they were being drafted, they were not able to capture the changing trends as we are seeing right now. And that's why in 2008, NEMA, together with other government institutions as well as civil society organizations, began consulting so that they would have a draft strategic assessment and integrated impact assessment regulations that are still yet to be adopted. But we have a long way to go, and it's one of the emerging trends we are seeing is that, for example, the Foundation State Development Environmental Impact Assessment study has tried to incorporate an issue of community development plans. So they're trying to really move away from the issue of corporate social responsibility, as you had mentioned earlier. So again, when it comes to EIAs, the big problem that we've had is monitoring and ensuring that these companies adhere to conditionalities of the license that they are normally awarded by NEMA. And for instance, in Turkana, the CDE, the NEMA CDE is located in Lodwar, whereas the activities are ongoing in Lokicha. So undertaking that continuous compliance monitoring tends to be a problem. The last time I was there with him in 2018, he mentioned it that they do not have a vehicle to undertake that. And when at one time when they went with the company, the perception with the community was that the company and NEMA are in bed. So it's also a challenge, and just trying to understand that because of perception and what communities are seeing, it's not been able. But what one of the other things that we can actually push for is having participatory approaches when it comes to monitoring, involving communities in assisting in the monitoring process. So those are some of the things that have been continually facing, but we are seeing a drastic change. We are seeing even in the contents of EIAs, they're slowly changing, but we still have a very long way to go.
Thank you very much, Moturi. You've alluded to the fact that 12 of MCA tasks the proponent to conduct self-evaluations. It is actually two-way. You can either do self or you get an expert to do it. So it's very hard for EIAs to be factual because the proponent pays for the EIAs, right?
Yes.
So difficult for an expert. I know they're professionals, but that issue of always the proponent paying the the experts to come up with an EIA has always disadvantaged communities. As we go to the second round, I'd like to start with you, Moturi. So you have like 2 minutes to answer this. Well, is there a waste management policy incorporated in the PSC? And how, moving forward, how can we ensure that it's there? You have 2 minutes so that we run through.
All right. As Charles had mentioned, PSCs have not been private to the public, but it is one of the things that really needs to be set in place, because that is one of the biggest challenges that is usually faced by companies that undertake upstream oil development. Currently, what companies need to adhere to is, for instance, we have the waste management regulations of 2006 that are already in place that talk about when it comes to waste handling. For instance, it talks about how to handle radioactive waste, how to handle domestic waste, how to all these things. So in the PSC, it's definitely one of the very integral things that needs to be to have been captured. But yet again, without knowing what exactly the contents are, it normally opens sort of a loophole for companies to tend to go against the norm.
Thank you very much, Susie. To Charles, in no particular order. Charles, as a follow-up question, there's the issue of local content. And then there's the issue of the Sovereign Wealth Fund bill. I'd like you to touch on those two issues because they're thorny issues, and the communities in Turkana have never managed to understand those two issues. How does money work from the proponent to treasury to the community, to the county? Are there ATMs that the community should expect to be given? So touch on those two issues.
Yeah, thank you. I'll start with the Sovereign Wealth Fund. And as you know, there's been a bill that's been going around for the Sovereign Wealth Fund. It was at Treasury. I don't know whether it's come out now. The last time we looked at it, we raised some concerns around how the access of a Sovereign Wealth Fund bill. And for purposes of people who might not be as knowledgeable on Sovereign Wealth Fund bills, the simple idea behind a Sovereign Wealth Fund bill is that you just don't spend all the revenues that you receive currently from your oil. And what you do is that you ensure that future generations also have access to that. In some instances, a Sovereign Wealth Fund bill can also act, a Sovereign Wealth Fund can also act as a stabilization fund, so that once the price of oil goes up and down. So for example, in the last month or two, due to COVID, the prices had collapsed completely. So for countries with a stabilization fund, like Ghana, for example, you tap into that fund to support your budgetary gaps, which have arisen because of the collapse in the price of oil. So, but at least in our instance, one of the key challenges we had with the bill was that it went the same way that a lot of laws in Kenya go. You open a lot of laws, or at least new laws, and the first sort of 10 pages is a human resource structure, right? So instead of even going down to sort of what the nitty-gritties of a solid law is, You start off by, so there will be a chairman appointed by whoever, there will be a secretary appointed to this, there will be a secretariat, there will be an executive director. So one of the challenges we keep finding is that instead of setting up solid laws, we are setting up patronage structures, right? So basically appointment structures as opposed to functionality. So in one instance, for example, in terms of functionality, instead of having a huge secretariat and that kind of thing, we can use already existing structures, either through Treasury or one of the other bodies, to ensure that a certain amount are set aside and invested for the future. On local content, we've been undertaking a similar process of setting up local content structure. But I must say one of the biggest challenges in local content is the governance structures. Again, the lack of transparency and accountability. I think Veronica had spoken to this in terms of access to opportunities for example, for women. So again, local content has, in some instances, been subverted to reward elites instead of focusing on opportunities for all within a community. So you'd find that either the national elite or local elite there are the ones who are capturing opportunities that would benefit communities. Now, another bigger challenge with local content is, so even now with force majeure, a lot of the companies that are set up there specifically to respond to these opportunities now find themselves in trouble. I know a while back, again, when Talo had slowed down operations, you had all these cars, which are set up in a specific way with a specific structure just to feed the companies. And sadly, what was happening is that the people who are more connected were the ones who are still getting access to opportunities, and just simple people who are just trying to, make themselves better, were not accessing these opportunities. So that's, again, the challenges in both instances, local content and the Sovereign Wealth Fund bill, is the lack of good governance broadly.
So even in second time round, we really have to work on those two aspects, because as it is, we do not have a policy framework to facilitate like a sort of a sovereign wealth fund.
I think firstly, we need to work on transparency and accountability. So there's a bit more transparency now, but there's just no accountability, right? So I'll give you another example where we know Talo has spent however many billions in Turkana, which will come out of profit oil eventually, if we ever go into production. But it's not clear where did all these monies go to, and ensuring that all of them were actually spent in the right and appropriate manner. So accountability to me is sort of the bigger thing, as opposed to not necessarily setting up completely new structures, but just being accountable.
Thank you very much, Charles. It's a big challenge, considering it's also Talo that is declaring the cost of oil. So you wonder when profit will be declared if the proponent is the one also declaring the cost of oil. I'd like to bring in Janet before I go to the community, then Lumumba will finish for us. Janet, take it away. Hope your network is, your connection is better.
Yes, I hope it's much better now. I'll try to rush through so that in case it drops again. Anyway, I was speaking about the subject matter of the case that Mheshimiwa had mentioned. And I had already stated, I hope participants got that the case was two separate cases, one initiated by the community, another initiated by the county government itself. Were consolidated. The subject matter is the same. Both petitioners claim not to have been consulted, and there is constitutional basis for their decry. And the interesting scenario here is that, can you hear me?
Yes, we can hear you.
Okay. The interesting scenario is that the county government basically plays a role of a trustee for the community. as far as community land is concerned. So when you see both parties separately initiate a suit in court, then it tells you, one, on the part of the community, they feel they've been left out of the process. And secondly, even their own trustee feels left out of the process. And even from the proceedings of the case and the ruling that is widely available, even online currently, you can see that the defense that the national government came with is that everything was transparent, everything was done as per book and as per the law, and that there's a lot at stake, such as the LAPSET project in general, the benefit to the rest of the country, other counties, even regionally, there's a benefit expected there. So basically, it begs the question, where does that leave the community itself and the county government itself? Because they're raising legitimate concerns. And secondly, the other issue that cropped up pursuant to the ruling in this particular consolidated case, in which the judge ruled that, yes, the two separate petitioners do have a case. The only issues that came into play is the intergovernmental angle. The Constitution provides that there should be utilization of alternative dispute resolution mechanisms before the court entertains such a suit. So it is not that the court has no jurisdiction. And in this case, we are talking about the Environment and Land Court. The issue is that there should have been exhaustion of preliminary measures, in this case, alternative dispute resolution. So this is what led to the court ruling that the suit would be stayed, not struck out, but stayed, and give parties 1 year to explore other alternative dispute resolution mechanism. Now, this has cropped a new issue that this ruling was entered last year in June 2019. Now, clearly, the 1 year period given by the court has now lapsed. So there was that period where they were supposed to have engaged in active consultation. And as you've had Mheshimiwa inform us, there seems to have been nothing going on, or rather on the part of the county, they have not felt consulted still. And that was an opportunity to remedy the situation, at least for all parties' concerns to be put on the table and appropriate resolution arrived at. Because as other panelists have outlined, there seems to have been a miss from the very beginning of the commencement of this project. There seems to have been a top-down approach as far as decision-making and such like matters, which now cropped into this compulsory acquisition matter, the subject of the case. And another case that bears relevance to this one is a previous case, petition 32 of 2017. This was a Nairobi petition in the High Court of Kelly Malenya versus the AG and others. Now, this case also, basically the petitioners were questioning the constitutionality of some of the provisions of the Community Land Act, such as even the definition of community land in itself and the procedure. Therefore, in a nutshell, the outcome of that particular case, the 2017 one, prior to the material one we're talking about, the court suspended several sections of the Community Land Act, such as sections 8, 9, 15, 21, 38, and 48. The court ruled that these sections are unconstitutional. So if you examine the instance where there was unconstitutionality of some sections, and this is when procedure was initiated, and now there was a lack of a framework, basically, for consultation, inquiry, participation of the community itself and the county government. And now, as I have mentioned before, there's also now a new cropping issue of even where there was an opportunity to remedy that situation, being the alternative dispute resolution mechanisms that they could have explored and have that sit down finally. that seems not to have taken place. So as at now, at the end of June, going into July, that 1 year period of alternative dispute resolution can be said to have not been effective. The only light at the end of that tunnel is that parties can now go back to court and proceed with the matter. And if there are any parties, such as the petitioner and the petitioners, the community and the county government still feel unheard and uninvolved, then that can now be addressed in the court exclusively. So the thing is that the court does have jurisdiction. It's just that the law provides that there has to be exhaustion of other mechanisms first. In addition to that, it will be interesting to see how the court rules in this, because the arguments leveled by the respondents, which is the national government, also portray a picture, actually substantiates the petitions by the community and the county government itself, in that the respondents, the national government, alluded to some workshops that took place between around the 28th of March to the 31st of March 2019. And these workshops seem to have only involved members of the public. Now, I've not heard Mama Veronica speak on participation or at least getting wind of such workshops. Therefore, the jury is out as to whether the public even feels adequately consulted within that period. And just from the face of it, as I mentioned, 28 to the 31st of March 2019 is a period of about 3 to 4 days. So the question that begs now is that really effective public participation within the meaning of the law in Kenya? But we are also alive to the fact that we still don't have, apart from Article 10 of the Constitution, we still don't have a conclusive framework on which we can peg public participation on. There have been several bills, and we still don't have legislation on that. And therefore, there's still a back and forth about what constitutes adequate public participation or adequate consultation in the case of the the county government. So in summary, these cases show that there's a lack of, or rather there's an absence of the social license to operate. The community itself has not given the operator that social license, and the county government has also not given their okay in the continuation of any of the operations. And this is the foundation of the stalemate that we find ourselves in. And every other stalemate that has occurred before, there's been issues before even the compulsory acquisition matter came about. My opinion would be there's need for adequate consultation, because at the end of the day, we want to, basically the national government is looking to make decisions on community land. Community land is very different from private land. Private land has set owners, you know who the proprietors are, but community land is held in trust. And there's also that sentimental attachment to that land. So, and as alluded before by other panelists, there's also the traditional mechanisms that they employ in utilization and even administration of that land. All this needs to be put into consideration. Therefore, community land needs to be treated more delicately or given special attention. And so therefore, in a nutshell, I would say this matter seems most likely to just go back to court and take off from where it left off, because parties seem to still be dissatisfied with the process and not have come to an agreement.
Thank you very much, Janet. You've mentioned very important issues, and it's a fact that legal processes can be lengthy, adversarial, and a little bit complicated. So the issue of ADR, it's something that the communities in Turkana should consider when seeking land justice. Ningelipenda kumleta sasa Mama Veronica. Mama Veronica, bado uko nasi? Mama Veronica ametoka. Tuko na Mheshimiwa Raphael. Mheshimiwa Raphael pia inakaa pia yeye connection yake pia sio mzuri. So Lumumba, I'll finish with you. There is Article 19 that speaks to prompt compensation. And then we have the Community Land Act itself that speaks about compensation and benefit sharing. But last year, an unconstitutional law was passed, the Land Value Index Act of 2019. It speaks about compensation regimes. It speaks about access to legal remedies on ongoing projects. Lumumba, I'd just like you to just speak to how does the latest act affect the cause for the Turkana people when they are seeking justice for their land, because it's clear that the Land Value Index Act of 2019 will frustrate them.
I think there are key issues that we need to bear in mind when we are talking about these things. And I will quickly want again to share with you very shortly 3 slides. And these slides will help me look through this. First, we look at the aim, goal, and purpose of the Land Value Index Act, and the one for the Community Land Act, 2016, the other one 2019. The Land Value Index Act was purposely put in place to provide the assessment of land value index in respect of compulsory acquisition, which means it was basically trying to assess at what level do they fix what they will compensate the affected parties, whether they are freeholders of the land in terms of private title or community land. So that seemed to be the drive behind it. But on the other hand, when you look at the Community Land Act of 2016, it seeks to provide recognition, protection, and registration of community land rights, together with the management and administration of community land. But it also goes further and provides for the role of the county governments in the relation to unregistered community land. And I think this is where the crux of the matter comes to bear. And it's against this background that we then want to look at what are the key issues in the evaluation of community land in light of the Land Value Index Act of 2019 and the Community Land Act. First, the Land Value Index Act infringes on the Constitution at Article 40 in terms of prompt payment in full of just compensation. This particular law, it went ahead to amend the Land Act in terms of the compulsory acquisition arrangement. It went ahead to amend the Land Registration Act. It also amended the Prevention and Protection of Internally Displaced Persons and Affected Communities. These laws were being amended so as to guarantee the fact that the government would compulsorily acquire your land but will not pay you promptly, but it promises to pay you in a year's time. And I think this is unconstitutional from the word go. And the people who came up with this act managed to convince even those at the county government to go along with them on this matter. Of course, those in the counties, they discovered their mistake after some time. That is the representatives of the county both at parliamentary and at the Senate. But the law had already gone through. So this particular act, I can firmly say that it infringes on the Constitution, and to the extent of that, when it comes to the acquisition of community land, it is basically void. The other element that is very key when we are talking about this devolution of community land, that this particular act tends to ignore the principle of free, prior, informed consent, that the people from whom you are trying to acquire land need to consent. Of course, we are talking about compulsory acquisition, where basically we are saying that the public purpose overrides. But we cannot ignore the fact that the manner in which community land is accessed, used, and passed on is fundamentally within the normative arrangement of the principle of free, prior, informed consent. The other element that is key to remember here is that this act seems to place much value on the market value approach. And it is within this that you will find lands that have been privatized and they have been developed to the extent of other attachment on the land. They are valued higher in the market than the lands that are within the territorial space which are yet to be developed. But this law is already trying to caveat the fact that development is coming now to this community land, which will uplift its value. That is not in consideration, and that complicates what it goes. For example, apart from oil, which we are discussing today, there are other infrastructure arrangements that come with it, and which now comes under what we call the lapsed corridor development infrastructure. And all this is falling in the same area, and it ought to be lifting the value of land in that area. But according to this particular act, that is of material assessment when it comes to the value of that land. Then, of course, the other element that is very worrying is basically about the community land to the extent of the delayed implementation of Community Land Act. What does that then mean? It means that the property rights of the communities are at crossroad to the extent that there's no firm recognition, protection that is being given to community property rights, because they remain land to the extent to which they will be on the record of the government register, so that the government now bequeaths it or gives it the appropriate property rights, which of course accrue from the Constitution, but are being delayed by the due process of doing that. And therefore, it complicates the matter further and further. So in a nutshell, I would basically say that we have a very major scenario, one law that even wants to negate the Constitution in a hurry to acquire community land compulsorily against such mega projects like the oil and the infrastructure that go with the oil. And we also have a law which is supposed to help the management of community land being delayed so that the other law, the land value index, can take place without the protector that comes with the Community Land Act. And that is what I could call the crosshairs that the community users of land, or that category of land, find themselves in.
Thank you very much.
To the facilitator.
Thank you very much, Lumumba. Just that there's the aspect of the unregistered, the inventory of unregistered lands. What's the legal implication of that? Counties were supposed to submit an inventory of unregistered land that falls within their jurisdiction. What's the legal implication of that, considering our oil and gas discourse?
I think the fact of the matter is that there are many things that the law has provided that have not taken place. One of them was that there was supposed to be the mapping of the nature of the customary nature of the land the communities were enjoying, which has never taken place up to date. And that ought to have been addressed. The other element, the value index law, the CS, the cabinet secretary is supposed to put in the mechanism in 6 months upon the commencement of that law. That has not yet happened to my knowledge. And I think all these things seems to complicate the matters of the community in terms of how do they really move. And I think more cases are going to come up in this Turkana case that are a major lesson going forward on any arrangements that we start that are hell-bent to cheat the community out of the whole arrangement of progress or development taking place in their own locality that ought to benefit them as a matter of fact and as a matter of constitutional provisions.
Thank you very much, Lumumba. I'd like to open the floor now. I can see I have 6 questions. Maybe you can display them, Victor. I can see I have 6 questions, which I'm going to allocate them to the panelists. We have a question from Abdi Salam. Hello, everyone. In relation to the community outreach, it is apparent that the PSC signed by Talo and its affiliate in the oil exploration agreement seems to lack the social welfare provisions, since ideally this doctrine is not part of the local content aspect we are used to. I will hereby suggest that the government of Kenya takes into account the CSR, Corporate Social Responsibility Programs, and IPECA, Industry Association for Environmental and Social Issues, since they provide good practice on human rights, social. Yeah, it seems like it's more of a comment because it's not been addressed to anyone. Mheshimiwa is back with us. Mheshimiwa? Mheshimiwa, naona umejiunga nasi tena. Mheshimiwa?
Nakusikia Faith.
Asante kwa kujiunga nasi. Ningelipenda sasa uweze kufunga, kupatia maoni yako ya kufunga. Wakati unazungumzia sasa Talo wanataka kutoka. Jamii yenye wewe unawakilisha, mmejipanga aje ndiposa msiweze kupata tena the short end of the stick?
Sijui vile nitakuambia. mambo huku sijui kama tumejipanga ama tumepangwa. Everything is done in Nairobi, and down here kila kitu imenyamaza. Nasikia tu Talo na Hama wameshaenda, you wame hand over everything to, I don't know, Chinese or what. Everything is done in Nairobi. Here we are just in darkness. In darkness. When we talk about land, hapo kabisa tuko na confusion mingi, because so far nothing has been reported to the assembly, either from NLC or from the office of the attorney, because walisema ile period waliweka iliisha, and once the period has elapsed, imekuwa sa national government imewin, because the government cannot sue the government. And for us, the community, we had nothing to offer to enable us fight for our rights in court. So ukienda continue naambiwa, you are coming as who? Provide anything, any documents. Unajipata huko zero. And now when the government comes in to represent their people, wanasema, how can the government sue the government? Sasa tunabaki hapo. So I don't know if vile tumejipanga. Tuko tu, maybe Mungu ndiye atatusaidia.
Tumeanza kujipanga mheshimiwa, tumeanza kujipanga na ndiposa ndio kwa sababu hao wataalamu wote wanaweza kusaidia kufikiria, wanawasaidia kufikiria. Kuna swali yenye nimefungua floor. Kuna swali yenye ilikuwa inauliza kama kuna mikakati yenye county assembly, kama kuna mikakati yenye county assembly inahusikana na kupanga wakati unazungumzia upstream development. Lakini nimesikia ukizungumza ukisema ya kwamba kila kitu inapangwa Nairobi. Kwa hivyo maneno ya Nairobi watu wa county hawahusishwi.
Hawahusishwa, especially where I stand.
Sawa sawa.
Hatuoni chochote.
Sawa sawa mheshimiwa. The next question is about environmental management. Muturi, I think you'll take this one. It's from an anonymous attendee. They're just questioning, why are we focusing on EIA, ESIA, and CEA process and don't see how the upstream production touches on possible water contamination, social structure, and the most important thing is the biodiversity of the land.
Yeah, thank you, Faith. One of the reasons why it's important to have frameworks such as EIAs and SEAs is because they tend to look at very critical aspects of the both social and ecological services, which are important because that helps you now understand what mitigation measures to put in place so that to address what issue. It also just ensures that in terms of environmental governance, project proponents are able to be held to account. But still, as well, project proponents also need to adhere to industry best practice. That is why the IFC performance standards such as 3 and 4 on issues of pollution and how environmental health and safety when it comes to communities. So companies, or rather proponents, also need to ensure that they do that. A good example, if I can give, is the Kingfisher fields in Uganda, where despite the CNOC having a very trying to have a very small ecological footprint, they have ensured that, for instance, where they handle where they store the hazardous waste, it is an area that has really gone through a lot of technological advancements, so to speak. They have aligned with the liners and the gravel, and then they've also been able to put up sort of concrete barriers. After which, when the waste is held for a certain period of time, it is transported to EnviroServe, where it is tested and incinerated, and it is able to be monitored. So those are some of the things that we need to look at. For instance, in the Foundation State Development EIA, one of the proposals is to have an integrated waste management facility that is going to ensure that the waste that is generated from the hazardous waste that is generated from the Turkana oil fields is incinerated, and it's also handled in a way that is proper. But also, it needs to the proponent rather needs to make it very clear that this is the process that is going to be set in place. These are the methods that they are going to undertake. What type of incinerator is going to be utilized, and how are they going to ensure that despite having sort of the landfill, what are the specifications of having that landfill? Because that is one of the very critical aspects when you're looking at issues of waste handling in the SAMs or the landfills. So these are some of the things that continuously need to be applied, and also just ensuring that with emerging trends in technologies, what are some of the things that are coming up that can also improve some of the waste handling processes from upstream petroleum development.
Thank you very much, Muturi. And then there's a question to Odenda. What are the land tenure issues that should be considered in Turkana? Maybe you just take a minute so that I give some people who I can see their hands up some opportunity before we close.
I had mentioned that one of the major issue that should be considered is this the law and policies being biased against the community category of land, because it is not considered as a property of the community to the extent when others want to access it, to acquire it, to retain it, transmit it to others. I think that process, which is basically an issue, which is basically borders the second element, which is basically the administration of their land holding. I think they seem to be on the double-pronged angle. There are the traditional structures of the elders, which seems to be the one occasionally is consulted, it ought to be managing, but there's also the other which is expected that has not come to place, which is a Community Land Management Committee. And yet there's the CEC in charge of land and natural resources within the county government, who is just doing land administration generally. And in many cases, he wants to apply, they want to apply themselves to community land. So that elements, those are the two major elements I normally see that really affects the enjoyment of tenure, because the community ought to help in determining how their land is accessed, exploited, used, and all those things. But apparently, where we are at, that is a bit in flux. It's not very clear. The lines are not well clearly drawn.
Yeah. Thank you very much, Lumumba. I can see 3 hands. You have a minute. Nasinyono Lesokon, you have a minute. Don't make a presentation. Nasinyono? Nasinyono, you can unmute. Nasinyono? Okay, we can move to the next. Laichena?
This is Veronica using Nasinyono's phone. Hello?
Yes.
Faith, it's because of the network. We have a problem here. I would like to raise something on community. As Lumumba was expressing how he has gone out with the issue with the community here. I believe in Turkana, we are still very far with the issue of the title deed. Especially title deeds to individuals is not workable for now. We're looking forward that maybe with Lumumba, if he can really aichengeze kwa upesi kuangalia mambo ya of lands, community participation on land issues. It's because hii yetu ni communal land. Sisi hatuone any titles. We would like kama kuna njia ya kufanya upesi tuweze kuhusika na mambo ya land, kwa sababu zetu hatujaanza kupata title deed. How fast will the government move at the national level ndio ikuje kwa county?
Asante sana Veronica, chenye ningeweza kukujibu ni kwamba titles ni mzuri, lakini titles haidhibitishi umiliki wa haki yako ya ardhi yako. Wakati unamiliki ardhi yako, unamiliki ardhi yako kama mwenyewe. Titles ni mzuri, lakini usiwache mtu akudanganya kwamba lazima upate hati miliki ndiposa ukuwe na haki ardhi.
Yes.
Sasa tukisonga kwa Elias. Elias, if you can us, please unmute.
Unmute. Ongea.
Yes, Faith.
Yes, it's your turn now. You have like a minute.
Can you hear me?
Yeah, I can hear you.
The first question is whether there is a fund where people of good wishes can send money to support the Turkana land cases. I am an advocate in London, but I practice in the High Court of Kenya. That's the first one. Is there a bank account? The second one is that Community Land Act, according to my understanding, is now the law. So it's not clear that the traditional land tenures are not existing in Kenyan community lands anymore. That is the law. Community Land Act is the law. So therefore, as we go forward, committees can be set up, consultation can be set up, but no one can take away the rights of the community over their land.
Elias, I agree with you.
Thank you.
Community lands are community lands, lands and territories.
And territories.
Yes, lands and territories. No one should take them away. It's just a matter of organizing so that we realize a better positioning and better organizing. Lillian Opondo, I had seen Ikal's hand.
What about the accounts? About the account to contribute money?
The account to contribute money, you can, I think we need a further conversation on that so that it is organized. We have organizations that have organized this webinar. We'll be giving contact so that you can reach out so that it's an organized sort of fundraising that we do so that at the end there's accountability and transparency in the process. We'll be giving out contacts of the partners. We have, I can't see Carl's hand anymore. We have Lillian Opondo. Lillian? 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 Okay, Cecilia? Cecilia?
Hi, can you hear me?
Very well.
Thank you. So my concern with the issue of community land in this case are also indigenous peoples, is that we don't normally have a situation where their rights to natural resources like plants and animals are taken care of beyond what we can see with the naked eye, because there are genetic resources that exist in those plants and animals. And those resources are subject to international agreements like the Convention on Biological Diversity and the Nagoya Protocol. And there are mechanisms for access to those kinds of resources, referencing here genetic resources. And you will find that when scientists or research community or other investors, companies access those kinds of resources, the communities also stand to benefit. So beyond the sentimental value and the cultural value that these resources have, there are other international rights that ought to be discussed and contemplated in matters involving communities and their lands. And so when we find like Mr. Odenda was just presenting that the full extent of the value of community land has not been done in a way that it can be able to be rationalized against now these so-called profits and other things, I think for me, it's a big loss for us not to take into account even the detail in genetic resources that exist within community land, because they have been known to benefit the community either through things like upfront payments, intellectual property, and things like that. So there are other rights which we should be discussing when we engage on matters community land. And I would like to see a situation where we actually go the extent of discussing this value versus the value of now the incoming investors who propose to bring in projects like these ones. Thank you.
Very much. I think we've had you. We are going to expand the conversation with time. There's Ikal. Ikal, I can see your hand. I think unmute.
Yeah, I think, can you hear me now?
You have a minute.
All right, quick one. So I think Odenda, you talked about CSR, but unless we have a candid conversation of what the CSR is and look at it from what is the government actually providing, because we are right now, why is everybody in Lokichar Basin asking about water? Because we let the oil companies take over the role of government to provide water. So we have to be very careful around the push for CSR and take into account that communities need to understand that CSR is not for free, that it actually is a cost to them. But also, I think in all this discussion, so many of us talk about benefits, but until we can candidly have a discussion around the costs and who's bearing the costs, because as it is, a very small group of people get the so-called benefits, but the costs in this case of Turkana, we are 86% pastoralists, and the discussion is held around the Lokichar Basin as if the pastoralists from the northern side have no access rights to that grazing area. So the discussion on oil in Turkana should stop being about the Lokichar Basin, but the entire Turkana, considering the migratory aspects of pastoralists and who we are as pastoralists includes migration, and grazing areas. So we have to start to expand this discussion away from only the Lokichar Basin. Yes, the cost will go to Lokichar Basin, but there are some costs that goes beyond the Lokichar Basin. And until we do that, if we as civil society keep focusing on the Lokichar Basin, we allow the MNCs and the government to keep pushing the rest of Turkana away, and because it is easier to deal with a small group of people, and in the end, dispossess them of their land and grazing areas. So I think we have to think about what role do we play in developing a narrative that excludes people from an access right that is theirs. So that's my position on that.
Thank you very much, Ikal. We'll expand the conversation. We're just sampling today. The last speaker for the day is Makena Kinoti. Makena, if you can hear me, we are starting to wrap up. Makena? Okay, so I'd like to come back and just, Makena? Okay, so each speaker only has a minute to answer one question. What can we do better now that we have another round, another opportunity to do it? It is like 30 seconds for each person. Let's start with Moturi. Moturi, 30 seconds.
Yeah, I believe that we've learned a lot from the whatever Talo has done. Whoever is coming in next, right now, I believe the Turkana community is well equipped to voice the concerns and demand a space at the decision-making table, because this is what affects not only them but also the entire country. So I believe that there's still a lot of work to do, but we are slowly getting there.
Thank you very much, Muturi. We have Charles, your 30 seconds. Is it another opportunity to do this again?
Sorry, can you hear me now? Yes. So I think on my part, I think what we need to do is, it's clear that there's going to be a new operator in at least in Turkana. And so as that process goes on, which will take a while, we need to sort of have a quick reflection on what has happened so far, and then ensure that as the negotiations go on and the new operator comes in place, that we are very clear in terms of what we want or the expectations of the new operator. So I think Ikal mentioned it very well as well, in terms of we've been delegating government tasks to the company. So how do you ensure that even before a new operator comes, that we are holding, for example, the Turkana County government to account on provision of services, so that when if the new operator comes into play, it's very clear in terms of what additional benefits we expect from them, and not things that we should be expecting from our elected leaders. Thank you
very much. We have Janet. Is Janet still online? You have your 30 seconds.
Yes, Faith, thank you. Mine would be to stress on the importance of having effective public participation and effective intergovernmental consultation and concerted efforts. This is the only way that expectations and needs can be effectively met, the social license can be secured, and both levels of government and their mandates can be effectively undertaken. Thank you.
Thank you very much, Janet. Veronica? Veronica, ningelipenda uko na dakika 30 uweze tu kufunga. Veronica, unanisikiza? Unasikia? Veronica? Veronica? Veronica inakaa yuko karibu. Mheshimiwa Raphael, dakika 30 uweze kutuambia ni usaidizi gani unaweza pewa na wenye wako na wenye wanakusikiza na wenye wamehudhuria warsha huu, ndiposa watu wa Turkana waweze kufaidika.
I want to support what Janet has said. Public participation is very key. A number of meetings have been taking place here for formality purposes. And when they report back, it's like the locals together with the government is fully involved. And yet, nothing has been taken into account. So my request is, if all of us can be included, inclusivity. Inclusivity will be taken care of, especially in the next process. I think that will be better, and our views should be taken into account.
Thank you very much, Mheshimiwa. Lastly, we have Odenda. Odenda, you have your 30 seconds. Do we have a second?
Mine is expressly, the first intention to develop oil was external to the Turkana people. Can they seize this opportunity and put the intention, now that the oil has been discovered, is there, so that in the next investment, the intention to improve on the standards of living of the Turkana people should be the ones to be negotiated, other than having that being negotiated on their behalf. I think that's my wish in the next round.
Thank you very much. Thank you very much, our panelists. Thank you for creating time. Asanteni kwa kujiunga nasi siku ya leo. Thank you. It's been a very informative conversation. Today we were focusing on the right holders. We are going to organize another one where we are going to focus on policy makers, so that the policy makers can also tell us how it is like from where they sit. Kenya Land Alliance appreciates all of us that have been able to log on. On that point, I'd also like to appreciate partners, the Kenya Civil Society Platform on Oil and Gas, the Kenya Network Platform, Network on Oil and Gas, NEDO, the International Land Coalition, and of course, Kenya Land Alliance appreciate partnerships. So watch out for the next one. The next one will be only having policymakers as well, and maybe some consultants to also represent community interests. This time round, we focused on right holders. Next time round, we are focusing on policymakers, and we hope you're going to join us again. For any questions or any other further collaborations that you'd like to have, you can approach the partners through, I'm sure they displayed some emails. Asanteni sana. Thank you for listening to me for the last 2 hours. Thank you for your participation. Thank you for your contributions. We really appreciate. Let's catch up for the next one as well. Asanteni sana.